This is a case of circumstantial evidence, your lordship.
हिंदी तो सही पढ़िए।
Yes, sir.
आप सब कॉन्वेंट वाले हैं, हम लोग हिंदी मीडियम वाले हैं।
Lordship, these are two connected cases. I'll be arguing from item number 3.1.
तो 3 के लिए कौन बहस करेगा?
I'll be arguing from the file of item number 3.1 for both the cases.
ठीक, 3.1 दे।
Yes, I've prepared this short synopsis, if your lordships.
हाँ, प्लीज।
This is a case, your lordship, where the applicant was arrested on 24/9/2021 in connection with crime number FIR number 627/21 registered at District Chaurai, PS Chaurai, District Chhindwara. The story of the prosecution, your lordship, is that on 22/9/2021, information was received stating that one head constable has not returned his home from 21/9/2021. Subsequently, your lordship, police inquired about the matter. They went, his body was recovered, his mobile phone was recovered. Police checked the records and subsequently got to know that one Rahul Nema had called. Subsequently, your lordship, Rahul Nema was apprehended, was arrested, and he gave a memorandum statement. On his memorandum statement, your lordships, both the present applicants before your lordships were arrested. Now, item number 3.1, your lordship, is a third bail application. The first two applications were dismissed as withdrawn. If your lordships would come to annexure A6, annexure A6.
Yes.
This was the second bail, wherein your lordships have, it starts from page 36 of the memo. This bail application was withdrawn as your lordships had pointed out that blood-stained articles that was the genes of the victim. Yes, your lordships. That was recovered from the applicant. And subsequently, your lordships had set a time frame and had directed the trial court to complete the trial within 6 months. Now, your lordship, till date, only 2 witnesses have been examined, and there are a total of 28 witnesses as per the charge sheet. Subsequently, your lordship, if I may be allowed to, if your lordships would come to annexure A4, annexure A3 and annexure A3, your lordship. Yes. It starts from page 25.
Yes.
The typed copy starts from page 27. This is the memorandum of the present applicant. Your lordship, मैं स्वेच्छा कथन करता हूँ कि मैं 4 व्हीलर सुधारने का काम करता हूँ, क्योंकि दुकान में करता हूँ, चीकू की दुकान में करता हूँ। राहुल नेवा सिवनी वाला चौराई में प्रॉपर्टी का काम करता है। मेरा अतुल चौरसिया से अच्छा जान पहचान है। अतुल से जान पहचान होने के कारण मेरी जान पहचान राहुल नेमा से भी हो गई थी। राहुल नेमा ने मुझे बताया था कि मैंने विजय से पैसा उधार लिया था, जो मुझसे पैसा मांग रहा था। मेरे पास पैसा का व्यवसाय नहीं किया। विजय की हत्या करने की व्यवस्था,
हिंदी तो सही पढ़िए। आप सब कॉन्वेंट वाले हैं, हम लोग हिंदी मीडियम वाले हैं।
विजय की हत्या करने की योजना बनाए दिनांक 21/9/2021 को 2 बजे के करीब अतुल चौरसिया ने फोन कर मुझे राहुल नेमा के ऑफिस में बुलाया था। वहां पर राहुल नेमा, मोनू ठाकुर, शानू कहार, अतुल चौरसिया भी थे। वहां राहुल नेमा बोला कि विजय को फोन करते हैं और यही ऑफिस बुलाते हैं और योजना के अनुसार उसकी हत्या कर देंगे और उसकी लाश को कहीं ले जाकर फेंक देंगे। फिर विजय को राहुल ने फोन लगाकर सृष्टि कॉलोनी चौराई उसके ऑफिस में बुलवाया और योजना अनुसार मैंने 3-4 रॉड ऑफिस में पहले से ही लाकर रख दिया था। दोपहर करीब 4-4:45 बजे विजय पुलिस ड्रेस में उसकी मोटरसाइकिल में से ऑफिस आया तो विजय को प्लान के अनुसार राहुल ने अपने सामने बैठाकर उसको बातचीत में लगा लिया। फिर मोनू ठाकुर ने विजय के पीछे तरफ से आया और योजना के अनुसार रॉड उठाकर विजय को जान से मारने की नियत से सिर में जोर से मारा। फिर राहुल ने भी रॉड उठाकर विजय को मारा। विजय जिंदा ना बचे इसलिए मैंने भी एक रॉड उठाया और विजय को मारा, जिससे विजय वहीं पर फर्श में गिर गया। जब खत्म हो गया था तब मोनू और राहुल ने विजय के दोनों पैर रस्सी से बांध दिए। विजय को जिस कमरे में मारे थे वहां फर्श में खून बह गया था, इसलिए मैंने राहुल नेमा, मोनू ठाकुर, अतुल चौरसिया एवं शानू उर्फ दीपक कहार के साथ मिलकर विजय की लाश को घसीटकर दूसरे कमरे में ले जाकर रख दिए। हम सब ऑफिस से बाहर गए और अतुल ने ऑफिस का ताला बंद कर दिया। जब अंधेरा हो गया तो राहुल और मोनू ने विजय की लाश को ऑफिस में रखे फ्लैकरत में लपेटकर राहुल नेमा की सफेद रंग की i20 कार में 100 नंबर की डिक्की में डाल दिया। इसके बाद योजना के अनुसार मोनू ठाकुर विजय की मोटरसाइकिल और मोबाइल को छिंदवाड़ा तरफ फेंकने के लिए गया और फिर योजना के अनुसार मैंने, अतुल चौरसिया एवं सोनू कहार तीनों ने मिलकर कमरे में पड़े विजय के खून को पानी से धुलकर साफ करने लगे तो राहुल नेमा विजय की लाश को कार में रखकर फेंकने के लिए सिवनी ले जाने के लिए निकल गया। विजय के खून से पानी विजय के खून को पानी से धुले परंतु फर्श से ठीक तरह से साफ नहीं हुआ, तो अतुल एवं शानू कहर ने 3 डिब्बा थिनर एसिड लिया। फिर तीनों ने मिलकर ऑफिस की फर्श में खून को थिनर से साफ कर दिया और मैं, सचिन और शानू कहर अपने अपने घर चले गए। That is the statement. Now, your lordships, my submission to your lordship is that this memorandum is not admissible for 2 reasons. Firstly, your lordship, that this was recorded on 24/9/2021 at 11:30 a.m. It is an established principle of law, your lordship, that in memorandum statement under section 27, only that much information can be given, which is not only previously known to the police and which leads to a substantial recovery. Now, if your lordships would peruse the case diary, all of these this information that has been allegedly supplied by the present applicant through memorandum was already known to the police, as memorandum of Rahul Nema was already recorded at 12:30 a.m. on 24/9/2021, and only on the basis of his memorandum, my name, the name of the present applicants were disclosed. Subsequently, we were arrested. Now, if your lordships would see that the witnesses to this memorandum, witness number 1 Than Singh and witness number 2 Jainath Baghel, both of these witnesses, your lordship, are the relatives of the deceased person. There are no eyewitnesses in the present case. We have been implemented
as of circumstantial evidence.
This is a case of circumstantial evidence, your lordships. I am relying on this judgment of Honorable Apex Court, which deals with detection of human blood in articles which are seized.
Please.
I'll directly invite your lordships to paragraph number 33. Before that paragraph, your lordships, there were conflicting views of the Honorable Apex Court with respect to detection of human blood, and subsequently it was, in many cases, Supreme Court has held that merely because blood is detected does not mean that the blood belongs to the deceased person. And in some cases, it has held that since blood is detected, it can be said that the accused person has committed the crime. So subsequently, your lordship, the Supreme Court has concluded in paragraph number 33. May I read, your lordship?
Please.
Therefore, as pointed out by this court in Balwant Singh and State of Chhattisgarh, there cannot be any fixed formula that the prosecution has to prove or need to prove that the blood group matches. But the judicial conscience of the court should be satisfied both about the recovery and the origin of human blood. Now, in the instant case, your lordship, the recovery is vitiated because both the witnesses are interested witnesses. The information that has been given by the present applicant was already known to the police officers. It would not come under purview of section 27. It is my next submission, your lordship, that the death has taken place on 22/9/2021.
Yes.
However, the recovery has been made on 24th.
Yes.
After 2 days, your lordship, it is rehearsed any reason. There is no reasonable explanation, your lordship, as to why a person who has caused death, who has caused murder.
When was dead body found?
It was found on 24th only.
Then that explains everything.
No, subsequently, your lordship, and the dead body has been recovered on the information given by the main accused person.
Rahul Nema.
Yes, your lordship. We have
Rahul
only
Nema के call details मिल पहले लाश मिली.
Yes. No. Firstly, he's called.
अच्छा पहले वो missing था तो call details मिला पहले.
पहले उसका phone मिला sir. Road के पास से. And the phone was checked. Subsequently, it was found that when Rahul Nema had called him, Rahul Nema was apprehended by the police authority. He was arrested by the police, and subsequently he gave his memorandum statement. On the basis
जहाँ phone मिला वहाँ से लाश कितना दूर मिली?
It is found, you know, there is some distance to that. I'll have to check lordship to that effect.
आपने अच्छी बहस करी है.
But I'll most probably submit your lordship for a moment. Section 27, if I'm allowed to read section 27, what it says.
Please. Evidence set. Please पढ़िए.
I'll read section 27 of the Evidence Act. How much information received from accused may be proved. May read, your lordship. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. So, your lordships, the confession that has been given by the present applicant that he has caused the murder, that is inadmissible. Only the part which says that his clothes were, yes, only that is admissible. That also may be admissible. Now, this section, if read along with the present memorandum, a conjoint reading of both the your lordship's documents, it would reveal that memorandum is not covered under this section because police already knew about all these facts and it has been recorded. The seizure has been made in presence of interested witnesses. So there is no sanctity to that seizure.
Interested witnesses के presence में seizure होगा तो वो vitiate हो जाएगा.
Your lordship, this is general law as per section 100 of CRPC. It says that in cases of seizure,
section 100 of CRPC. ये किताब दीजिए इनको सबको. Section 100 CRPC पढ़ने के लिए. पढ़ी है सेक्शन 100 पढ़ी है। ये मेरे हाथ में ही दे दीजिए, ये सीआरपीसी है, दे दीजिए। लीजिए किताब लीजिए, आपके पास है सीआरपीसी?
I have the manual.
ओके, पढ़िए प्लीज।
It says, Your Lordship, that search has to be made in presence of.
पढ़िए, whenever any place.
This is whenever any place is liable to be searched or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer other than executing the person executing warrant, on production of warrant, allow him to free ingress thereto and afford all reasonable facilities for search therein. If ingress into such place cannot be so obtained, the officer or other person executing the warrant may proceed in manner provided in subsection 2 of section 147, where any person in or about such a place is reasonably suspected of. It is in fact section 102, Your Lordship.
102 पढ़ लेते हैं।
Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found in under circumstances which create suspicion of commission of any offence. Such police officer, if subordinate to the officer in charge of a police station, shall forthwith report the seizure to that officer. Every police acting under subsection 1 shall forthwith report the seizure of the magistrate having jurisdiction.
इसमें भी नहीं है।
There is one section, I'll point it out, Your Lordship.
बताइए।
But that section says, Your Lordship, that seizure has to be made in presence of independent witnesses. The respectable citizens of the society. That is how the wordings of that section is. I'll point it out.
Citizen of the society is a very wide term.
But my submission to that, Your Lordship, is, since this is a case where seizure has to be made, that too, and which will, in a case of circumstantial evidence, Your Lordship, the link has to be so complete that only one reasonable explanation should be there that the accused persons have committed crime. In this case, Your Lordship, since the witnesses themselves are prosecution witnesses, they are themselves related to the deceased, they are bound to say that in front of them these
आपके कॉल डिटेल्स और राहुल नेमा की कॉल डिटेल्स मैच कराए क्या?
I bow down to that, Your Lordship. My call details were never seized. My phone was never checked. Only Rahul Nema's phone was checked.
यही तो दिक्कत है, इनको इन्वेस्टिगेशन करना ही नहीं आता था। जो चीजें 8वीं के बच्चे को मालूम होती है वो इनके इंस्पेक्टर और डीएसपी को नहीं मालूम रहती है। अरे आप इत्मीनान से बहस करिए, घबराइए मत, आपको सुनूंगा मैं।
I have
not show any hurry.
Yes,
ठीक है, because it is my duty to encourage young members of the bar. आपके सीनियर होते तो I would have cut short him, but आप तफसील से बहस करिए, डरिए मत।
Yes, Your Lordship. My call details were never checked, Your Lordship.
ठीक है, that is ancillary.
My submission is, Your Lordship, only thing against me in the present case is my memorandum under section 27. Now that memorandum, Your Lordship, is
how you'll account for the recovery of your jeans, Article H.
Your Lordship, the circumstances are so suspicious that it should not be weighed against the present applicant.
Okay.
In both the cases, in fact, Your Lordship, the seizure witnesses are interested persons. It has been seized after 2 long days, Your Lordship. The prosecution story is that खून जो scene of crime पे था, वो हमने साफ कर दिया, पर हमने अपने ही कपड़े साफ नहीं किए. That is so suspicious, Your Lordship. Even after 2 days, a person who has committed murder would not clean his own clothes. That, Your Lordship, police says खून जैसा कुछ है. It is also not conclusive whether blood was present or not. Only on this apprehension, Your Lordship, the present applicant should not be kept behind bars. They have already undergone an under trial imprisonment of around 1 year, more than 1 year. There is no direct evidence to that against the present applicants, Your Lordships, and the judgment of the Supreme Court squarely covers the case that even if blood-stained articles are recovered, the court has to be sure about the nature of recovery. The seizure has to be.
ऋषभ जी, जो मेन इशू जो आपको आंसर करना है,
yes, Your Lordship,
वो ये है, what are the changed circumstances after dismissal of second application when your senior argued this matter?
It was second application. I'll most probably submit.
उतना से बताइए, second circumstance बताइए.
The second application was withdrawn, Your Lordship. Subsequently, the
मैंने अभी नहीं हुए हैं.
Yes, Your Lordship.
मैंने नहीं हुए.
I bow down to that, Your Lordships. However, another witness has been examined. Subsequently, PW2 was examined.
PW2 ने क्या कह दिया? उसकी एविडेंस पे आइए, वो आपको कैसे सपोर्ट करती है? Let us read PW2.
These are all family members of the accused person. If I'll read what PW2 says, Your Lordship. He has deposed as if he was an eyewitness to the case. I'll start from paragraph number 2. It is at page 61. Deposition. Paragraph number 2. फिर थाना चांद पुलिस ने मृतक विजय बघेल की मोबाइल से कॉल डिटेल के आधार पर अभियुक्त राहुल नेमा से विजय बघेल के संबंध में पूछताछ की। राहुल नेमा ने बताया कि उसने लगभग 1.5 साल पहले मृतक विजय से 12 लाख रुपए उधार लिया था। मृतक विजय पैसा बार बार मांग रहा था, जिससे वे परेशान हो गया था। फिर अभियुक्त राहुल नेमा, मोनू ठाकुर, अतुल चौरसिया, सोनू कहार और सचिन शर्मा ने मिलकर विजय बघेल की हत्या करने के लिए योजना बनाया था। योजना अनुसार दिनांक 21/9/2021 को अभियुक्त राहुल नेमा ने विजय बघेल को फोन लगाकर उसकी सृष्टि कॉलोनी चौराही ऑफिस में बुलवाया था और सामने वाली कुर्सी में मृतक विजय को बैठाकर बातचीत में लगाकर पीछे से मोनू ठाकुर ने आकर जान से मारने की नियत से मृतक विजय के सिर में पीछे तरफ से जोर से रॉड मारा। They also know the intention with which the assault was made, your lordship, as if they were present at the spot. फिर अभियुक्त राहुल नेमा ने भी रॉड उठाकर मृतक विजय को मारा। अभियुक्त अतुल चौरसिया ने भी मृतक विजय को रॉड उठाकर मारपीट किया। मारपीट करने से मृतक विजय फर्श पर गिर गया और विजय की मौत हो गई थी। फिर अभियुक्त राहुल नेमा, मोनू, अतुल, सोनू ने मिलकर मृतक विजय बघेल के हाथ पैर रस्सी से बांध दिए और सभी अभियुक्तगण ने मृतक विजय बघेल की लाश को खींचकर दूसरे कमरे में लेकर गए। फिर सभी अभियुक्तगण ऑफिस से बाहर हो गए। अभियुक्त अतुल ने ऑफिस का ताला बंद किया। They also know who has closed the doors of the house and has locked the premises, your lordship. अभियुक्त ने ऑफिस का ताला बंद कर दिया। फिर कुछ देर बाद अंधेरा हो जाने पर अभियुक्त राहुल नेमा और मोनू ठाकुर ने ऑफिस में रखे फ्लैट्स में मृतक विजय की लाश को लपेटकर राहुल नेमा की कार कंपनी क्रमांक सो एंड सो में डिक्की में डालकर लाश डाल दिए। इसके बाद अभियुक्त मोनू ने मृतक विजय की मोटरसाइकिल और मोबाइल को लेकर उत्सव रिजॉर्ट छिंदवाड़ा के पास ले जाकर मोटरसाइकिल को रिजॉर्ट के सामने खड़ी कर दिया और मोबाइल को झाड़ियों में फेंक दिया और मोनू वापस सिवनी आ गया। अभियुक्त सचिन, अतुल और सोनू कहार ने मिलकर सृष्टि ऑफिस के कमरे की जहां पर विजय की हत्या किए थे उस कमरे की पानी डालकर सफाई किया। उसके बाद अभियुक्त राहुल नेमा ने अपनी कार क्रमांक 100 की डिक्की में मृतक विजय की लाश को लेकर सिवनी तरफ निकल गया। रास्ते में राहुल नेमा ने अभियुक्त मोनू को अपने साथ लिया और कार से 2 ग्राम बमोड़ी बरघाट रोड बिस्लेरी फैक्ट्री के सामने बर्रा जिला जमीन पर पहुंच गए। वहां पर राहुल नेमा ने एक जेसीबी वाहन को बुलवाया और वहां पर गड्ढा खुदवाया। गड्ढा खुदवाने के बाद राहुल नेमा ने जेसीबी चालक को बोला कि तुम यहां से दूर चले जाओ क्योंकि मुझे जादू टोना करना है। और फिर अभियुक्त राहुल नेमा ने राहुल नेमा और मोनू ने
रिसोर्ट है ये राहुल नेमा की है?
नो योर लॉर्डशिप,
ये किसकी है?
योर लॉर्डशिप, इट इज अ प्राइवेट रिसोर्ट।
अच्छा, इनका ऑफिस कहां पर है?
That is at a different place, your lordship.
उसके संबंध में कुछ पूछा ही नहीं, जो क्रॉस करना था वो कुछ पूछा ही नहीं।
But if your lordship would see the main evidence which is against the applicant is that mobile phone was recovered. Now again the circumstances are so suspicious, your lordship. If I have caused murder, if I have murdered someone, why would I leave his mobile phone at an open place? That particular piece of evidence should have been destroyed by anyone who has committed the murder. That, to your lordship, the main allegation is against Rahul Nema. Everything is against Rahul Nema.
आपसे पूछ कर नहीं गया ना वो?
No, your lordship, that is not the case. My submission is that, your lordship, all these witnesses have deposed as if they were the eyewitnesses.
ठीक, I'll consider.
And I have undergone 1 year's
I'll consider. और श्री ऋषभ सिंह and श्री आपका शुभ नाम डालिएगा, लर्नर सीनियर एडवोकेट फॉर जी applicants, Shri Vivek Lakera, learned government advocate.
Melody, the order is positive. Only his name.
अभी तक आप समझ गए क्या ऑर्डर है? लेकिन आपका नाम डालता ही नहीं। Thank you. But you argued well.